ruling, or the most significant ruling handed down by the state Supreme Court in the last 20 years, and why?
Okay, John, I can't answer that question.
Well, you couldn't answer the guitarist either.
There's a pattern here. I'm going to answer the question, but I'm not going to be able to answer. 20 years. Professor Fallone is an historian. I'm sure he's going to be able. I couldn't pick out the best or the worst case, but I am going to mention 4 cases that have been decided by the Supreme Court that did establish tremendous consumer rights. And they were my cases, but that's not the reason I mentioned it. It was Dieter versus Chrysler, which happened in 2000, and that said that a manufacturer of an automobile is going to be responsible even if a car dealer messes up at delivery or messes up with the car. A huge case. 2004, Garcia versus Mazda. That said that a consumer can make a lemon law demand on her own without absolutely following everything that the lemon law says, because the lemon law is for consumers. And the quote from the court was, consumers don't carry statute books along with them every time they go someplace. In 2011, Marquez versus Mercedes, the biggest lemon law case in the United States, and it's still going on. They paid us $618,000 so far. They still owe us $300,000. It set forth the guidelines for what is bad faith in a lemon law or consumer act claim. This not only helps us in Wisconsin, because that's been a mess for a long time. Manufacturers would argue, it's bad faith. Now they can't do that because the Supreme Court has set forth guidelines. It also helps the United States because there isn't any other decisions in the United States on what is bad faith. And the last case is 2012, Killian versus Mercedes-Benz, which set the standards for people who lease cars and what their rights really are, which is very helpful because we've got 60% of the deals are leases today. I went over, and this gentleman didn't yell.
Graciously, gave you the 10-second rule. Thank you, Vince. Let's get Ed Fallone. I don't know whether you're going to give us 4 cases or 1, but...
Well, every case is important to the parties. Every case is the most significant case in the world to the parties before the court. It's hard to pick one out over the last 20 years, but what I will do is I will underscore a 2011 case that raised a very important legal issue with practical implications for all of us, and was completely mishandled by our state Supreme Court, and I think which demonstrates the dysfunction that I was mentioning earlier. The case is called State versus Forbush, and it dealt with when law enforcement officers have to stop interrogating a suspect because they've learned that suspect has a lawyer. And what was important about that issue is it happens all the time. And law enforcement needs guidance. They need to know what are the constitutional rights of the accused, when can you interrogate a suspect, and when do you have to pull back? And is it because you learn they have a lawyer and then you pull back? So we needed guidance from the state Supreme Court. And the exact rule the court adopted didn't really matter so much, as long as it spoke clearly so that law enforcement could train their officers on the proper constitutional way to conduct interrogations. And how did the Supreme Court act? Did they give guidance? No. They had 5 separate opinions with multiple rationales. The justices couldn't agree on what the Constitution required. And when the case is over, it's worked its way all the way to the Supreme Court, and law enforcement is waiting for guidance. When it's over, the law was more confused than the court found it. And there is no guidance, and to this day, there is no clear rule on when the police have to stop an interrogation when they learn the suspect has a lawyer. And that's because the court can't get along, they can't compromise, they can't work together, and that's an example of an important issue left unresolved because of the dysfunction of the court.
Ed Fallone, thank you. The next question that folks before from SPARC is a very optimistic one. It is about where you'd recuse yourself. which is presuming you're going to be on the court, because you can't recuse yourself now. But they're interested in knowing, and let's start with that on this one. What are there cases from which you would recuse yourself, and what would your standard be?
The standard for recusal, the judge, when a judge steps down and says, I can't hear this case, should be where the judge's impartiality is rightfully questioned. And in large part, that's often because the judge has a financial interest in the particular case, or financial relationship with one of the parties, or with one of the lawyers representing the parties. And there you might say, okay, the judge has a personal financial stake in the outcome. Certainly, they should recuse themselves in that circumstance. I think that there have been a lot of games played with the recusal rules. And I think there's been some political game playing to try and argue judges should recuse themselves from certain cases to get them off the case in order to influence the result. And certainly what I reject, and John alluded to this earlier, is I reject the argument that anyone who signed a recall petition has to recuse themselves from any case involving Governor Walker. There's nothing in the Wisconsin statutes that requires recusal based on an expression of political opinion. There's nothing in the Code of Judicial Conduct that requires it. And in fact, we know every judge goes to the bench with political philosophy, with a record of voting for certain candidates. No judge is a blank slate. And when you hear these arguments that anyone who signed a recall petition has to recuse themselves from a case, this is simply an attempt to interject politics into the judicial process, and it's wrong. And I certainly will never recuse myself on a case involving Governor Walker because it's not required, and I don't think it's proper.
It's Megna.
I agree with everything Ed's said.
Thank you very much.
Especially the last statement. I will not recuse if Walker's involved either. But recusal is difficult. I want to give you a couple examples, real life examples, because this happened, and it's telling. In the Marquez case, Marquez versus Mercedes, after maybe the second Court of Appeals decision, it's sent back to the trial court, and Judge Ramirez is the judge it's assigned to. And we go to a scheduling conference, and I know that my client, Marquez, knows Judge Ramirez. So it's brought up at the conference that Judge Ramirez knows my client. They're good friends. The judge eats at his restaurants, they socialize, but the judge says, that's not a problem, I can act fairly. And that's a question, can you act fairly and be a judge that the people would want? So he doesn't recuse himself. We leave, 2 days later, we get in the mail a recusal by Justice Ramirez. 6 months later, I found out why he recused himself. Because when he went home, his wife said, you better get off that case. The other case, Killian versus Mercedes. I was at the judicial conference late at night after the judges had been drinking, and Justice Ziegler was talking to me, and she said, well, you know, I'm a good friend of Killian in the Mercedes case. I'm going to have to recuse myself, but you guys are going to get a fair shake. You're going to get a fair shake of it. So that was interesting. I was happy to know that we're going to get a fair shake, and she did recuse herself. There's two examples of two friends, two friend issues. One recuses and one doesn't, but then is told to recuse by his wife. One quick thing, and in that band I was telling you about, I played with two judges, Maudsley and Judge Neil Nettershine at the Court of Appeals. They never recused themselves when I was arguing or had a case in front of them, ever. And they rendered fair decisions. We always won, but they were fair.
Maybe they didn't want to lose you from the band.